Good afternoon, everyone, and welcome back to another episode of Speaking Legally, where the legal meets the cultural. We're here again with our two co-hosts, Royce Russell Esquire and Edward Pichardo Esquire. We thank you for joining us, tuning in every week, 4 p.m. Eastern Standard Time. Thank you for sharing it with your tribe, your friends, letting them know that this is where you get your real information about how the legal impacts the cultural. So I'm going to turn it over to my co-host so they can say hello. But before I do that, happy birthday again, Ed. It's still Libra season, and you know my
Yeah.
Libra season. And on Sunday I turn something again, 25 again. So
Yeah.
to the show, hey Jason, how you doing, my brother? Good to see you here joining us on the show. But I'll turn it over to my co-host so they can greet you, and then we're going to get in to another Power Pack show for you.
Well, let me just start off to say hola. There you go, Ed. A little Spanish. Hola. Abogado Royce Russell or Senior Royce Russell. I just want to welcome everybody back to Speaking Legally, where the issues are hot and heavy and right on time because we have our thumb on the pulse of what's going on in the community and in the news, locally and nationally, just because we got it like that. We season like that. We in the know like that, and we can predict the future. All right, and I predict LA will win tonight. So that's part of the prediction. So Ed, why don't you just slide on in here?
Lord.
Well, hello everyone. Hola, buena tarde a todo el mundo allá afuera, escuchándonos aquí esta tarde. Hello everyone at Pichardo. I welcome you to today's show. I think once again you're gonna find it fact-packed and fulfilling, and I think you're gonna really like this show and the information you get out of this because I think it's gonna be you're gonna find it quite educational. And as Roy stated, for some, we seem to just be on the pulse. What the issues that we discuss seems to be so relevant that right after we talk about them, they appear somewhere on the news, and so it seems like timing is everything, and it's definitely working in our favor. So welcome today. Welcome.
Absolutely.
Dr. Grant, why don't you lead us in on, I heard a little stat. Why don't you lead us in on our subject matter today? Because it's hot and heavy in the news.
It is, but I want to say hello to Richard Russell II. Thank you for always being here. Hey, Prince Haile Selassie IV. And Jason, of course, we appreciate you being here. So everybody's talking about what's going down in Louisville, Kentucky, and the grand jury. Once again, we are dealing with a situation where we're seeing a lot of narratives in the news. And today we're going to break down some of the facts that we know that were happening. And we're going to get an education on what a grand jury actually is. How do they get selected? How does this process really work? So when you're having your barbershop conversations, sidewalk conversations, socially distant, that you can be equipped with facts and not just emotions about what we're seeing play out in real time, unfortunately, once again, in our communities. And I will say before you start that my prayers continue to, I know all of our prayers go out to those on the ground in Kentucky that are lifting their voices up for justice, those who've been working in the community to try and advocate for rights prior to this. We don't want any of their work to go in vain. And we know those that are there supporting and agitating so that we can get proper answers. We want to pray for their protection too, because there's a lot going on. But I'm going to turn it over to you, Mr. Russell, because you have a lot to share with educating us about what it means to be on the grand jury. And you're going to talk about how to get picked and just a lot of the nuances that are different from regular jury duty. So over to you, Mr. Russell.
Well, let me say this, right? Everybody has an opinion, and I'm all for everyone expressing an opinion. But as I say in cardiac arrest, and I'll say it here, opinions are only worth something if someone has the facts, someone has the experience, someone has the facts and experience to have an opinion and therefore worthy of listening. So when you come on Speaking Legally and you listen to us, here go a little fact. A little fact is that I was a prosecutor for 5.5 years on the state and the federal level. So what I'm telling you about New York and what my partner is telling you about grand juries in general, having served as an executive with Kings County and Brooklyn, New York District Attorney's Office, having been a public defender in, Milwaukee, Wisconsin, whatever that foreign land was that you were at, Ed, when you first started your career. But you know what I'm saying. It's important that you listen because we're not speaking from the hip And we're not just speaking from the lips, we're speaking from the brain. And so I say all this to say, get your pen, get your paper, write down the episode, and retain this knowledge. So when you're talking about this sensitive issue of Breonna Taylor or anything else, or anyone else, you can speak from a position of power and knowledge. And so with all that said, I bet you everyone doesn't know when grand jury really started. The word even came up, how it even evolved. And I can tell you, it goes back as late as 1215 AD. 1215 AD. That's in the English system where we first heard the words of bill of indictment, presentment, and now it's just called indictment. And grand jury are those that serve and listen to cases both on state and federal level. So what is a grand juror? A grand juror is an average person from the community, and they make the decision whether or not charges are going to be filed. Now, to a degree, they make a decision as to what charges, but they don't initiate what charges. The prosecutor comes in to a room, present charges. The grand jury then makes a decision as to those charges. Now, that is different from a trial juror. A trial juror will determine guilt or innocence. Guilt or innocent is for the trial jury. That is not what a grand juror does. A grand juror is a step before, and they make a determination as to what facts and evidence was substantiated in the grand jury to move forward. So if you said, I stole a car, those charges go before a grand jury. The grand jury hears the information. Either they support or dismiss. So when I looked up the definition of grand jury, although I lived being a prosecutor and working with grand jurors, I found the words that they use was very, very, very suspect. And why do I say that? It gives an impression that the grand jury and the prosecutor work hand in hand, which is really not the situation. The grand jury is supposed to act as a checks and balance. So let me tell you what the definition says. The definition says the prosecution works with the grand jury to decide whether bringing criminal charges or indictment goes forward. And that's not really the words I would use. Prosecution works with the grand jury, because you're not working with when you're a grand jury. You're not supposed to work with. If you hear that language, you need to cancel that. You need to correct the person. You are there to serve as a checks and balance for the information that's being presented to you. Now, why do I say that? I don't say that because I'm a Black man living in America and I need that to be the case. I say that as a former prosecutor because if I can't meet my burden in the grand jury, if you can't check and balance me in the grand jury, I damn well ain't going to meet my burden at trial, where the standard is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. So the grand jury serves as the first gateway to having an understanding whether or not your hand is on the right pulse or not. So I'm not, as a grand juror, working with you. As a grand juror, I'm here to check you and to check the facts and make sure you dot the I's and cross the T's, so then I can substantiate that you need to go forward. And you, as a prosecutor, can say, hey, look, I went to the grand jury. The grand jury says we're moving forward. Hey, defense counsel. Hey, Mr. Pichardo, you might want to speak to your client because the grand jury said we're moving forward. So there's an independent body that says what I presented, which is probably not everything I could present, there is evidence there to move forward. And so when I look at who is made up, what's the numbers? Because we're always concerned. We know jury is 12 when it's a felony. Misdemeanor is 6. I'm gonna hog the mic for a minute, Ed, but I'm just gonna lay the law down. So I don't want you to be surprised. I'm just gonna hog it up, jump in when you can, but I'm gonna eat this mic up because you're playing in my backfield here, right? So we know, in the felony level, trial jurors is 12, right? And the misdemeanor juries is 6. And the grand jury consists of 23 individuals. 23 individuals sit there, and they're there to hear case after case and to make determinations whether charges should go forward. You need 16 of the 23 to move forward. So that means you walk in a room, and they usually call them panels. Panel A, panel B, panel C. You walk in a room, and panel A only have 12 people that came in today out of 23, you know you can't do any work in it. You have to go to another panel because you need 16. You need a quorum. And then after you present all your evidence and they heard all the charges, you need at least 12 individuals that heard every single thing that went on as to that case to vote and come up with a conclusion. It'll probably be more than 12, but you need at least 12, right? To come up with the conclusion as to whether or not you're going to move forward. And so what does that look like? There's a couple of options that can happen after all the evidence is presented, or some of the evidence, or what a prosecutor thinks should be presented to get to the next step. The grand jury can vote what they call a true bill. That means that an indictment is coming. That
true
means
bill of particulars.
Right, a true bill. And so that means that an indictment is coming, and that means you have stepped to the next level. Other side of the coin, they can vote no true bill. They can say, we don't believe anything in here, or we don't believe a couple of things in here. So as to the felonies, dismiss. Third option, misdemeanors, we keep. And so therefore you could be facing misdemeanor charges when you were originally facing felony charges, because in the grand jury, I'm going to have the grand jurors hear the higher charges and the lesser included charges. So the grand jury can say, we don't believe the higher charges. We just believe the lower charges. Then the option that a lot of people don't even realize, you could be charged with crime A and B, and then going into the grand jury after evaluating the elements of the facts, the grand jury can say, or at least the DA and the prosecutor, assistant district attorney could say, you know what? We can also try to get him on C. And you're totally unaware that C even existed. On your initial paperwork, it only said A and B. But there may be a theory for C, and you're not even cognizant. And the district attorney doesn't have an obligation to call the defense counsel and say, you know what? We've been looking at the paperwork, and we're charging this person with A and B. But as we look closely, we think there's C and D in here. That may not be lesser included. Might be.
And Royce, how about the situations where you were able to get a true bill of particulars on A and B, and the prosecutor decides to go back in to try to get C?
And that can also happen. And on top of that, you say, well, what does this all mean? It means that you're in a lot of shit in hot water. I'll tell you that right now. That's what it means, right? If you have a true bill and new charges are brought forward, that means you're in a lot of hot water. But as we discussed earlier, and we talked about bail and what it means to be out on your own recognizance, release on your own recognizance, once an indictment comes through and a true bill is issued, then the prosecutor has the right to ask the court to raise bail, change bail. We have new evidence here. We have a new condition. Your Honor, before he was just accused of something. Now we present it to the grand jury. Now he's indicted. So we have a litmus test, and for which we know that there are people that are not tied to us to believe that we should go forward. And you should consider that in raising bail, changing bail. That's the bad side. Negative side. Let me lend a little positivity. The good side is that if they don't have a true bill and you're only left with misdemeanors and you have bail, you can argue the reverse, which is, Judge, they presented their case to the grand jury, came back with no felony charges. My client should be released so we could try this case in misdemeanor court. Now, that is, in essence, what grand juries do and how that whole system is played out. Now, let me add the cultural to it, because that's what we do, is speaking legally. We take the legal and we add the cultural. The culture is, if my man Ed is standing and he sees one of the grand jurors walking through the hallway and he says hola, or he says something that they recognize that's from the neighborhood, or they recognize like, oh man, I thought he was, African American. Now he said something in Spanish. Now I know he's Spanish. Guess what? That individual feels a nexus to Ed. Feels like they're connected to Ed. And when Ed walks in there and Ed says A did B, that person is like, you know what, as my man, he just said hola in the hallway. Now,
and
I'm being a little facetious and a little shallow, but it is not. I'm not being untruthful. So,
and I think what Royce is alluding to on that level is you could be disqualified from serving on a jury if you've been convicted of a felony and you haven't received a pardon or what's called a certificate of relief from disabilities, which negates the effect of the conviction, if you will, that will allow you to serve. And so we talk about that because there are a number of people in our community and communities of color who've been convicted of felonies, and they're not always violent felonies. Okay, you could have the old lady who can't serve because back in the day she got convicted of a felony for writing a check or welfare fraud or something, whatever it is, some property offense is what I'm trying to get at. And so now this person has a felony on their record and they can't serve. So now what happens is those type of issues affect the makeup of grand juries all over the country in various communities, urban to suburban. And then you start thinking about class and who's serving on those juries and whether they believe certain things or not, and whether they catch the cultural nuances or not, or do they find the witness that the prosecutor put in the grand jury credible? Does it even make sense to them what the prosecutor is saying and the indictment itself? All those things play a role. It plays a role really because that grand juror has to determine whether the evidence that's been presented sufficiently supports that charge in the indictment.
and now the grand juror's responsibility. I'm sorry, Dr. Grant. The grand juror's responsibility is to hear the elements of a crime, hear the facts, and make a decision whether or not they should move forward. That is their basic mission and job. If they don't see that and they don't hear that, then they can go another direction. Hold on 1 second, Dr. Grant. Mm-hmm. What I was alluding to and what Ed spoke to a little bit before we get into the requirements of being a grand jury, because I do want to go through that, is that sometimes that mission can be compromised and abandoned because the prosecutor has a relationship with the grand jurors. I'm in that grand jury every other day. They see me every other day. They are pleasantly surprised when I come in one day with one bow tie and look one way with glasses. Then I come in the next day with another bow tie with another pair of glasses. I like to dress. Let's put it together, right? Right. And so now they feel like, wow, this guy is sharp. Yesterday he came in looking like this. Now he comes in looking like this. They start to feel a certain way. It's human. It's human, right? I mean, it's what we do. Oh, he said he grew up in the Bronx. I heard him say something about a St. Mary's project. A jurist walking to the bathroom. All these little tidbits, all these little things start to marshal a person and starts to create a relationship that you're not even aware of, or maybe you are aware of. I know I was aware of it when I was a DA. I knew I was speaking to my people from the Bronx. I knew where they went, and I could laugh at the areas and we could smile. And I knew my ability and the power I had to shape and mold what was a good case and what was a bullshit case that I was forced to put in the grand jury by my superiors. So if it happened to me, I know it's happening across the world.
Absolutely. So I want you to continue, of course, to get into how you get on a grand jury, but I want to underscore, because you all are ripping through this information, explaining what it means to be on the grand jury and what their job is. But I want to underscore the culture.
We do that on purpose, Dr. Grant. We rip through it. So we rip through it so our listeners will have to watch the show twice, right? We want 2 times the view. So it's intentional.
And I get it, but you know me, I'm gonna pause for the cause and underscore what we want them to take away. And part of what you're discussing right now is critical when we talk about serving jury duty. We did a whole show on why it's important to be on the jury, and you just explained the difference between trial juror and the grand juror, and the importance of also if you're serving as an attorney, whether a prosecutor or a defense in your community, there's more of a likelihood that you will have that common ground with people who are chosen for a grand jury and
Correct.
or trial jury. So we need more people going into the professions where we have a voice, where we have someone who has
Correct.
capacity to advocate and work on our behalf, like the two of you serving as attorneys within communities where you live, work, and serve. So I want to just highlight that for our young people as well, who are angry right now, watching different things go on. It's an opportunity to say, if you pursue this kind of career, put you in a position where you can be an advocate for your own. But now I definitely want you to go into detail of how the heck do you get on this 23 person grand.
Right. So I'm gonna go through this, and I'm gonna still do a lot of ripping like I'm on that treadmill, because I like to do my 5 miles a day. Don't stop me now, because I know we want to talk about Breonna Taylor on the back end of this. And so before we could talk about that, we need to raise our level of intelligence and information and advocacy. So, as what does it take to become? What is the requirement to become a grand juror? And this is important because it's definitely cultural when you realize what it takes. All right, you have to be a U.S. citizen. You take that for what it is culturally. A lot of people are legal permanent residents. They didn't become citizens. You excluded from the process. How about that little cultural tidbit? Have to be 18 years of age. Well, we need to stop shooting in our community so some of us can live to the year 18 years old. How about that little tidbit, right? No felony convictions. But if you have a felony conviction, you need to be smart enough to press your attorney to say, I want you to file for me a certificate from relief of civil disability, a certificate from relief for civil disability, which will allow you to apply for certain state and federal jobs and will allow you to sit as a grand juror. How about this? You have to vote. This is where they get the people from. This is how they get your people, right? They get your people from people that vote, right? How else? You get your people from people that have unemployment insurance, right? Those are the people that you get that become part of the grand jury with those other requirements. So if you don't have a driver's license, if you don't have any ID from the motor vehicle, if you're not registered to vote, if you don't file for a certificate of release for civil disability from civil disability, you're not even on the radar. Forget being 18. Forget being a U.S. citizen. Forget having the ability to communicate and speak in English, because that's a requirement. You can forget all that because you're not even on the radar. And when we talk about length of time of serving on the grand jury, is anywhere from 2 weeks or more, usually around about 60 days, could be 30 days. And you don't meet every day. You meet once or twice a week. That's why you have so many different panels. It is not so ominous on you that you got to, oh my God, I'm here every single day. No, it's every other day. It might be 2 days. It might be 3 days. And if you serve as a grand juror, you don't have to serve as a juror for another 8 years if you stay more than a week or more than 2 weeks as a grand juror. If it's less than that, you don't have to serve for another 6 years. So there's no reason why we shouldn't be in the mix. There's no reason why we can't get a seat at the table, except for we're not registered and we're not true stakeholders. We don't have a driver's license. We don't have a valid ID from the motor vehicle. We're not employed, so the unemployment part is an issue. And guess what? You can also become a grand juror just by doing one simple thing. You can volunteer. That word is a scarce word. You know what I mean? I can't even get that word on the Scrabble board. It takes too many letters. So people are running away from that. But if we're talking about effectuating change, then that's what you need to do. And that's what we need to do. And, people talk about going in and presenting cases to the grand jury and, worry about seeing stuff. And I don't want to go in the grand jury because I don't want them to target me as someone that was part of whatever event that I saw. I'm just going to use this term. We're not going to sit on it long because we want to move on. Immunity. You could walk in there with immunity and not get charged with anything. You could walk in the grand jury with a waiver of immunity and say, hey, look, I saw what I saw. I do what I do, and I'm ready to move on. Let me just educate our viewers to one more thing. And then we're going to hit that hot topic of Breonna Taylor and what happened in Kentucky, because it's extremely important. As I say, you need 23 grand jurors, 16 is a quorum, 12 votes you need to move on, right? You do have position, right? You have the foreperson in the grand jury. In the grand jury, that's the person that swears everybody in. You have the assistant foreperson. That is a person that swears people in when the foreperson is not around, because there are times when people miss grand jury. They just don't make it that day. But the most important person of them all is the secretary. And the secretary of the grand jury keeps track of how many people heard the case, when, and where. So that means you can have some people say, I was here on Thursday and I heard that case. And the secretary looks at her book and say, you was not here on Thursday. You did not hear that case. So therefore, you can't participate in the vote as to whether or not there's enough to move forward, whether or not there's an indictment, or whether there's a true bill, or whether there's no true bill. So the secretary is key. So I don't want you to think that being a grand juror is just positionless and you just go in there. There is checks and balances. And a grand jury, I don't want anyone out there walking through society, oh, the grand jury just works with the prosecutor. No. Grand jury serves as a checks and balances for the prosecution and for the community itself. Now, whether they do it or not is something different. But you can do it if you become a grand juror. So now, I mean, that's the educational part. And so let's jump on this, Breonna Taylor, because it's all about who, what, and when, and what was told, and what is the cultural obligation to everything.
It's more than hot and heavy. I mean, we've seen the outcry, the insult. We talked on the show about the fact that the officer that was charged was the one whose bullet never touched her. And we went through that through the show. But now there's some breaking news. See your pajamas, right? What's the breaking news going down with a grand juror?
Well, the big breaking news this week is kind of twofold here, because the big news is that the Attorney General is supposed to be releasing a recording of the grand jury proceedings. Now, why is that big?
Because he was ordered.
One of the big things is that if we didn't mention it earlier, we certainly want to drill this into your mind. Grand jury proceedings are supposed to be secret. They're supposed to be confidential, okay? It is very rare for grand jury minutes, if ever, to get released. And in fact, when during the Eric Garner proceeding, there were motions made to the court to release those grand jury minutes, and the judge refused. I believe in Ramarley Graham as well, the court refused to release. Here in Kentucky, you had basically an interesting set of incidents that occurred. Protesters, the family attorney, Benjamin Crump, they were asking for the grand jury minutes to be released because of the result that you only had these wanton disregard charges against one out of the three officers for shots that were fired into the homes of neighbors, not even at or into the apartment of Breonna Taylor. And so you've had outrage, you've had protests regarding that, and people want to know, well, what was it that was presented to the grand jury? So I believe during the arraignment proceeding on Monday, Judge Amy Ann Bailey Smith stated that the grand jury minutes were to be released and placed into the court record. And so that order was made, and the AG was forced to now agree to the release of the minutes. But then later on that evening, like about 4-something, one of the grand jurors filed a motion anonymously, remember, secret, anonymously through his or her attorney, filed a motion asking that those grand jury minutes, that grand jury testimony be made public, and also, in addition to that, is asking for a declaration of rights, a petition for declaratory judgment. Why? Because that grand juror is sworn to secrecy as to those proceedings, and that grand juror wants the public, or wants to be able to talk about what his or her experience was in that grand jury. What was it that happened there? And let's keep going. Why is that? Reason being that the family of Breonna Taylor and many others are saying, wait a minute, the AG told us that he was going to do X, Y, and Z. Now, this is
let's stop right there, Ed. Let's stop. That's why I said, and I'm with you all the way. That's why I said who, what, and when. Those are critical questions that needs to be answered. Who, what, and when. Who spoke to whom? Did the Attorney General? Now, I'm just speaking from experience, right? I've done civil rights cases, false arrest, wrongful death cases. You can go from Ramarley Graham, Kowalski, Treywick. You can even Sean Bell, where we first met years ago in the beginning of that, right? Yeah. We can date ourselves on wrongful death cases that I have been involved in from beginning to end. Now, my experience has told me, at least in the Bronx, former District Attorney Robert Johnson, the way that office was run and the way I ran my practice and run my practice is that we want a meeting. You're going to sit with us. We're going to have a conversation so we know what's going on. So there is no surprises. That's good lawyering. You want to make sure that you minimize the shock to the family and manage expectations and have an understanding of what's going on in the pursuit of justice. And in those cases, the DA said, this is what we're going to charge. This is what we believe in. This is what the facts have shown us. Now, I take that and I look at Kowalski Treywick, new ADA Clark, look at their team, kind of moving the ball a little bit, not really saying what they're going to charge, not really doing certain things. However, at the end, made a great presentation once they decided not to move forward. But during the process, the transparency was, the shade was half up. It wasn't fully up. The light wasn't coming all the way in. Now, the reality is that they don't have to let any light in. They can pull the shade all the way down, right? You could do that, right? But if you're going to let a little light in, then where's the conversation? So now that's why I stopped you and said, who had a conversation? Did the Attorney General have a conversation with the family of Breonna Taylor prior to presenting the case in the grand jury? Did they speak to the family lawyer, not Crump, but the family lawyer that was present? I think it's Sam Aguilar or something like that. And they had another family lawyer and Crump. Did they speak to protesters or those that were involved in the civil groups and that may have been present at that meeting and said, we're going to charge A in the grand jury? And then did the Attorney General go in there and not charge A and charge B? Was there a meeting that said, we're going to charge A, but we don't think we're going to get it? So we're also going to charge B, and we think we're going to get that. So who had what conversation and when? Is all this happening at the end? Now people are talking to one another. Now we get the information. Because if he went in there and said, A, I understand what the grand juror is saying and filing a motion. Hey, boss, you trying to tell me that you were in there and said you're going to show evidence for a homicide. We only came back with wanton recklessness. You never presented anything with a homicide. So don't try to, when you get the mic, try to, disparage my name.
Well, it's interesting. It's interesting that you say that, because the crux of the motion is not so much about the statements that were made prior to the proceedings.
Exactly.
That's not what the attorney argues. What the attorney is arguing is that the statements that were made at press conference and other media communications by the AG are not in line with what occurred during that proceeding. Because basically, and I would say it's not just this AG. I think to the general public, the ideas put forward, just like you mentioned earlier about we work with the prosecutor works with the grand jury, right?
No,
right? But I'm saying you said that. Well, I don't really see it that way. Okay, now what's generally presented to the general public is that we just put forward all the information to the grand jury, and they on their own decided what the charges were going to be. And what we're trying to clarify here to our audience is that no, that's not the way it goes down. What goes down is that prosecutor has charges that they're looking to indict that they present to the jury, and they present
on
exactly ahead of time.
It's like a kid. It's like a kid asking their parent, "Can you read me a bedtime story?" Right? And the kid may go get his favorite book, but the parent decide what chapter they want to start on. Like, yo, do I really have the autonomy?
No, yeah. So what's happening here is that, you know, the one of the particular arguments here is that the grand juror is saying is, listen, I got my summons to appear as a grand juror. I appeared, I served. Why are you now trying to make it seem as if me and my fellow grand jurors were the ones who decided on these particular charges? You know that's not how it went down.
And not only that, Ed, I don't know if this person is black, white, or Latino, but I tell you, if I'm a grand juror and I live in Bronx County, or I live wherever I live, and a case of this magnitude happens, and I'm picked as a grand juror, and I go in there, you only presented A, and then you come back on the microphone and you want to start talking about, oh, how the grand jury missed the ball on B, and I gotta walk my black ass still up the hill. Oh no, you're not. No. This is where the culture and the legal meet. That's not happening, boss. Guess what? I need to write this motion so I can be heard, so you can understand that that's not what you did. You're doing what we call, 3-card money. You know what I mean? Which card the chip is under. Don't start flipping. And no, we're not in a polo grounds. We in the court. Don't start flipping the cards. We're not on 46th Street. We in the court. You said A. You brought in A. We went with the charges of A.
So hold on a minute. As you continue to talk about this, did he now say he needed more time to redact information about names? And does that take that long? I'm just saying, like this.
Well, listen, he's asking for some additional time to do that. He's going to be able to argue that it's legally consistent with the whole notion of the grand jury proceedings being secret. They're actually going to be releasing a recording versus the actual transcript, is my understanding, which is, another nuance here. I mean, the bottom line is that, the fact that this stuff is being released is just, it is big. There's nothing small about this. And what'll make it even larger is, which hasn't been discussed yet, because the motion is scheduled, I believe, to be argued on October 5th. So I'm imagining that Attorney Kevin Glogauer, who's representing this anonymous juror at that time, is additionally going to be able to argue, or is going to be arguing for his or her client to be able to disclose their experience in the grand jury, which is going to be a layer beyond. I mean, I don't know with the release of the transcript whether he may just say, you know what, that's good enough. I want to maintain the anonymity of my client, fine. But if he goes forward and moves forward with that motion, and that judge decided that, yes, this grand juror has a right to disclose, man, that gets into the case law and it doesn't get reversed. And then, that's used later by other grand jurors to want to.
And I'll add to this, right? Here's what we call a compromise. It could happen. The judge can say, you can speak, but you can't speak to the particular facts, right?
Exactly.
So now you got a grand juror saying, yeah, I remember on Tuesday when they came to present so-and-so, they came in the door laughing, or they came in the door smiling, or I remember somebody blundered and somebody corrected them. Those are the things that we talk about, are the little things that give people the hint that something's foul or something's not right. Or remember they came in and the guy started talking and then they had to stop and they had to go out and then come back in. How about that? They had to stop, go out and come back in. What about that? Those are the things that, all right, you don't want me to talk about the facts? I'll just talk about the experience. That's
how How about if they only presented like certain testimony and didn't even present testimony on whether or not they knocked, and later on said, okay, well, we'll bring back a witness and only bring the one witness? Because that's a big deal that people are making, that are people discussing are, wait a minute, there was more than one person who's stating that they did not hear these officers knock. So you only choose to bring the one witness to support this theory that they actually knocked and announced.
And I will tell you this: the case is tough as it is, right? I mean, let's remove the civil rights part of it, and I'm just squarely having my prosecutorial hat, criminal hat on it, and trying to convict these police officers for a homicide, negligent homicide, intentional, you name it. It is tough as it is, and this is why, even with Robert Johnson and even with the present DA Clark, and any DA, the DA in Queens at the time of Sean Bell, you name it, I don't understand the inability, and I'll tip my hat to ADA Clark because her team was diverse. The inability to have a diverse team when you're presenting these cases.
So there's another question that Richard raised. Is it legal or illegal for an employer not to pay an employee if he serves or she serves on a grand jury? And could that be a reason why many people of color don't want to serve? So I think that's good to add as we're talking about the importance. And hats off to the grand jury that decided, no, you're not going to put the gag order on me. I'm going to find a way to speak up.
Well, one, yeah, you're supposed to get paid for your grand jury service. They tell you that is in the rules, is the regulations. I think it's like $40 a day, and if you there more than a certain amount of days, it becomes $6 an hour on top of that, or some number like that. But you're supposed to get paid. You're not supposed to be terminated.
And that's the key. You're not supposed to be terminated. Yeah,
right. You're not supposed to be terminated. Nothing punitive is supposed to happen. But we do live in a world that those things happen. You just have to have the fortitude that if it happens to you, you just knock on the judge's door and get whatever letters you have to get. Do the follow-up, and that argument will go nowhere, and you'll be vindicated.
Yeah, like I mentioned at the end of the last show, I believe for the municipal employees and for the, public authority employees, like the transit employees, those employers, those large employers, they actually pay you your regular salary if you serve. So, in terms of, and I know that the in particular New York City's workforce is heavily of color. So in many cases, there's no reason why those folks should not be serving on juries, grand juries, like we said, because there's a difference there. You may get called for jury duty and end up doing grand versus, being selected for a actual trial. So.
Well, again, when we deal with this situation here, what is going to be critical to the truth telling, because that's what we try to do on this show, right? At least my mission every single day is to be a truth teller, whether it is pro con, like it or not, take me as it is once again, who, what, and when. If he made promises pre going into that grand jury to the family and attorneys of Breonna Taylor, and it blows up that he didn't live up to those promises, not that he didn't get the result, that's something different, that he didn't live up in presenting it, or he presented it in a skewed fashion, we got Houston, we got a problem, right? Now, if he said nothing, and we assumed that because the color of his skin, that he was going to go, and the nature of the case, he was going to go in and present charges that were equal to or equivalent to or surrounded around the death of Breonna Taylor, then lesson learned on us, shame on us. And as Bush says, you fooled me once, and he messed up that quote, but you fooled me once, right? That assumption was a bad assumption on our part, because we shouldn't assume anything, because every brother's not a brother, and I don't know him personally, but I'm just saying things and position and power and facts may have you move a certain way. So maybe we shouldn't assume that as a community. And then 3 is, if he didn't say what he was going to charge, it was our assumption But then he went in the grand jury and he went in with a very limited scope. And his post indictment statement made it look like he went in there with a broader scope. Then what spook sat behind what door? That's a problem.
Well, and that's with meeting the cultural here, like you said, people may have assumed because of the color of his skin and his origins, because he was, I believe, born and raised there in Kentucky, not Louisville, but some nearby community. They thought that, oh, okay, this brother's gonna possibly do the right thing, even though I believe he was general counsel to Mitch McConnell, who's, you see what he's doing, in line with the president of the United States. But I've always told the people near me, whenever it came to these big cases where you were relying on a prosecutor to prosecute these officers, I've always told folks, listen, grand jury proceedings are secret proceedings, and that prosecutor is going to depend on what they present to that jury for the most part, and that's going to dictate what the outcome is going to be. And we already know that if you're talking about some conservative DA who supports law enforcement and is pro-law enforcement, then you always have to be concerned about what it is that they're going to present in that grand jury proceeding. Okay, and that's going to most of the time be consistent with the outcome, because people have said, a prosecutor can indict a ham sandwich in a grand jury, and what they meant by that normally is that, listen, that prosecutor has the evidence in their hands, they have the witnesses, they're alone with that jury. Most of the time, their presentation, if they're bringing that case, a lot of the times it's successful. And they also get, different cracks at the apple. If they don't get that true bill of particular the first time, they can marshal up some more evidence and try to get it again. So, on a cultural level, we gotta, once again, in terms of the voting and the franchise and who you elect as the DA, and even if that person isn't of color, what pressures do you put on that DA, because that is an elected official, to do the right thing, to say, hey, listen, wait a minute, you're asking for re-election, and 3 years ago when that young boy got killed by those officers, what did you do again? What happened in that grand jury?
Not only that, when you look at the process is a process where the prosecutor goes in uncontested to present the facts.
Yeah, there's no defendant. There's no defense attorney.
That's right. No defense attorney, no one to question it. So the question becomes, how good a job did you do? Or in my transparency world, when it comes down to this, why don't you just play it like you see it and just put it all out there? And let it come back the way it is, right? If you think you have a slim chance of meeting the burden of a homicide, let's just say you think that. I don't necessarily believe in overcharging, because I wouldn't want that to happen to anyone, right? But if you believe that is the case, then there may be some theory. Then maybe you charge that and you let it fall on his face. Or maybe you do a memorandum to the file way before you go in and lay out what your rationale is. And we could do the metadata on that, have it preserved. When it doesn't go the right way, go the way that people think, hey, look, I wrote this memo 3 weeks ago. We can check the metadata. It says I wrote it 3 weeks ago. I didn't think we were going to make it with that, so I went with A. Here it is.
And I want to just point something out, okay? A defendant does have the right to appear before a grand jury. Yeah, right. The thing is that defense attorney has to notify ahead of time that they wish to be present to testify at the grand jury. A lot of times that doesn't happen on a very practical level, because you don't want your client to be exposed to questioning in the grand jury. But I just want to
without the protection of a lawyer being able to object, and without protection of a judge being able to stop certain questioning from happening, because once you're in the grand jury, once again, is an uncontested presentation.
Now I've seen some counsel, some defendants take that risk and have come out, successful under some very, limited circumstances, but it's rare. But I just wanted to kind of point that out to folks.
Well, let me just tell you one thing, Ed, and I have participated as a defense counsel where I brought a guy in a grand jury, didn't like the way the DA was conducting it as if it was a trial. The grand jurors got the feel. This is what I mean by cultural. Again, they can pick up on it. They got the feel that a shim sham was about to go down. And when I grabbed my guy and said, "We're out. We're not doing this anymore. You go ahead." And they came back with a no true bill. They were feeling it. They saw it. They saw it with their own eyes. They saw what was going on. And so it can happen
if you have the right person. So it goes back again to having the right people advocating for you in our communities. We have 2 questions that I want to get to from our audience before we wrap up. And I want to thank Shawnee and Lil Miss, Constance and Deborah and Monica and all of you who are to Noel. And I'm going to get to your question. John, thank you for tuning in. So Jason made a comment, not really a question. He said the sad part, they tell jurors to follow certain protocols when deliberating, but they're dealing with people who you can't unring the bell once you suggested a bias. And in the jury room, all those biases come to the forefront in jurors that are delivering their rulings. Would you all agree or disagree? And then we'll get to Noel.
I agree. And that's why, as jurors, I tell everyone, you bring in your life experience in that room, and I need your life experience.
And that's why it's important to serve jury duty. I confess too. A lot of us see it as an inconvenience, like, oh my gosh, jury duty. But if we're not there, how can it be a jury of our peers? Once again, cultural note from our show. So Noel said, since all investigations should start at the beginning, can any of you elaborate on why the AG refused to investigate claims that the officer who applied for the no-knock warrant lied, perjury, in his application to the judge regarding drugs being previously delivered to this address? Postmaster contradicted the officer's claim, and if the officers gained the warrant illegally, what are the ramifications? Why not investigate that?
Well, the answer to the question is that he didn't want to. The answer to the question is that the people in Kentucky voted him in, and he has the power to do it or not. Now, that brings up an interesting little tidbit. That's a different charge. That's a different level of investigation. So maybe he could circle back with that on the state level. Go ahead, Ed.
Well, you got to also understand there are some complications in this case. The original prosecutor recused himself, right? You got that problem because they weren't willing to basically investigate themselves. Like, for instance, the DA's office in Brooklyn has their own internal office of public integrity, and they're willing to investigate themselves for misconduct. That's why you have some of these convictions on the motion of the DA being overturned, some long-term convictions where you've seen an injustice occur in the past and the person serving time. To answer your question, more readily, it's the AG has punted that investigation, unfortunately, to the feds, and they're supposed to be investigating that part of it for that fundamental, violation of the law in terms of whether or not, the information that was presented to the judge who ultimately signed the warrant, whether that testimony or that information was false. Because, people have been questioning the judge who signed this warrant. She's saying, listen, I asked all the questions that I needed to ask, and, I signed off on the warrant. So, now it's a matter of, someone being able to find out, well, listen, whatever that judge signed wasn't true. And so now we have to circle back. I mean, it's definitely a good question for sure.
It's a good question. The penalty at most is a year or probation, or you get fired. It is, second place is last place. And I don't even really want to hear about it, but I thank you for your question, because it's a teachable moment for everyone out there that, it ain't over until the fat lady sings.
And listen, I've spoken to some prosecutors, as recent as this past weekend, and law enforcement.
You speak to prosecutors, man? You speak to prosecutors?
Yeah, I like them too. Folks here in particular in New York are talking about, in order for you to get one of those types of warrants, the judges here, the bar here in the city of New York puts prosecutors through quite a few hoops in terms of their information to make sure that before they sign that thing, and I'm talking about most judges, not all, but the general experience by the prosecution bar is that judges give you a hard way to go before they go ahead and sign off on something like that, because they want to make sure. You don't want to be the judge who signs off on that type of warrant and something like this happens, because people are going to ask, well, did you ask them how recent that sale that they're claiming occurred in the affidavit? How recent was that? What date was that? What was it that? Explain to me, this part here, before they go ahead and sign off on that thing, because, God forbid you go in there, look, here, this supposed guy that's supposed to be in there wasn't even living over there anymore. And then there were questions about whether or not they even had the right apartment, and it was a mess. It was an absolute mess. And some people are claiming actually that, oh well, it must have been that whoever, they might have been using a confidential informant, and possibly that confidential informant wasn't giving them accurate or timely information. And the question is whether they should have been relying on that individual for the basis of the warrant, because you'll see in these affidavits, CI, who we have used on several occasions and has provided us with reliable information in the past, is now claiming that there are drugs being sold out of apartment, blah, 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 and most recently on this occasion, and that individual saw several weapons in there, and, or a method by which evidence can be destroyed, etc.
One of the things that I think this case will do, and hopefully it does it on a national level, and once again, I thank Noel for his question, is that it'll hopefully shake the conscience and the boots of everyone that use these confidential informants that are paid, right? I know it is a process to get information, but the veracity has to be tested over and over again. It's almost like using a sobriety calibration machine to test to see if someone is drunk or not. You cannot use the machine and leave it there for weeks and months and then use it one day and think that it's reading correctly. That's not the way it goes. It has to be fresh. It has to be accurate. It has to have some level of truth to it. And we all know oppression, in reference to how police conduct and do their business, saying that I got the information, a tip from a confidential informant without a search warrant is an excuse that is used often when it comes down to people being stopped. Or we got a tip that this car had a gun in it. Or we got a tip, this very vague, very, unverifiable mode or excuse or statement.
Unfortunately, I tell you, it's so much to discuss, but here's where the legal meets the cultural, that we can get into the conversations and empower you to have the information to speak intelligently about it, but more so even understand it for yourself, because therefore the grace of God go all of us. We're not exempt from anything. We see that in 2020, all of the people who've been in the news didn't think they were going to be in the news for these unfortunate situations. But Jason had a last question before we wrap up our show. He said, at any time can a juror request more information for clarity in their deliberation process?
And this is why I started out, Jason. I want to make sure that you go see the beginning of this episode here, so we can make it loud and clear. And I don't mean it facetiously. I just want to make sure that you understand this, because that is a great question. The grand jury should serve as the checks and balances. And being a check and balance individual, you have the right to ask for more information. You are the checks and balances. But I know Jay already knew that. He's just doing that for all the other listeners out there. And I got a wink and a nod for him. I appreciate it. But that's the reality. The reality is that you don't work with the prosecutors. You don't work for. You don't work against. You are the checks and balances to make sure that someone needs to go through the horrible process of being a defendant.
Absolutely. So, this has been another great show with information and content that you can share out. We air every Wednesday, 4 p.m. Eastern Standard Time. You can catch the replays on both Mr. Royce Russell's page and Edward Pichardo's page on Facebook. You can catch it on Desi Designers TV or my pages. It's about us getting the information to our community. No one's coming to save us. We're going to save ourselves, and we're going to help you find people who are on the ground every day, like Mr. Russell and Mr. Pichardo, advocating for our rights and helping us to achieve justice by the system and push for reform where it's needed. So we thank you all for being here. I'm going to let them say their final words, and then we're going to close out our show today. And Libra season continues, and countdown to the birthday girl. But Mr. Russell, final comments, please.
Final comments. You heard the word, embed the word, understand the word, spread the word, and also happy birthday to Dr. Stacey Gray.
Thank you. Ed, over to you.
Yes, indeed. I'm definitely a believer that knowledge is power and education is the passport to the future, as Malcolm X once said. And so, that's the reason why we do this show. We try to give you the information. We invite you to even verify what we're talking about here and check up on it for yourself.
Say law enforcement. Say law enforcement. I did. Say law enforcement.
Exactly. So listen, I'm glad you joined us this afternoon, this evening. I hope you found the information fulfilling. And once again, happy birthday, Dr. Grant. Wish you the best. Fellow Libra. We celebrating. We doing our thing.
Oh, you know what? And I'm real quick. Deborah Johnson just signed on. Everybody, look, she's at the 4-6 precinct, and she's keeping it real. I went down not too long ago to sign a book, Cardiac Arrest, a tactical guide on how to handle unlawful police stops, at her precinct, where I met a Detective Wilshire who said the book was phenomenal and he wanted to spread it all through the 46th precinct. I appreciate you. Yes. I appreciate you passing the business on. It is past another litmus test that the truth needs to be told, and that's why we're here today.
Absolutely. And thank you all for the birthday. It's Sunday, 10-4, but I celebrate all month long. But I appreciate all the love. And Deborah, thank you. A whole month. That's right. Libra season. I start in the Virgos. I push them out, and then I bring in the Scorpios.
It's all you see what happened, Ed? You see what happened, Ed? You see how that go down?
Yo, that's how it is.
Yes.
Even Halloween, you just knock out Halloween right off. You just keep it moving.
Yeah, we running around without scales. Like,
look,
girl, that's what we do.
All I get is the 4th of July weekend. You know what I mean? Like, that's it. She got the whole thing. She got the whole.
Sound like a lot, Poppy.
Yeah, you would say that. Of course.
You get the fireworks of the whole nine. It's summertime, barbecue, boogaloo. Right. Stop.
Okay. And the red, white, and blue. If you peep.
Hey, yo, you can wear the red, black, and green. Ain't nobody stopping you.
You pay for me doing this show with my two brothers.
Look, I just get stopped without the red, black, and green. That's the problem, brother.
I can't. The show is going to end, y'all. But on a serious note, I thank you all for the love. It's fun to have a little levity. We're dealing with a lot. We know a lot of you are going through a lot. And know that our prayers and our love go out. COVID-19 is not gone. Our numbers are spiking again in New York. People wash your hands, social distance. We have to be careful. We're dealing with the racial pandemic, global pandemic of COVID-19, financial unrest. Is a serious time. So where the legal meets the cultural on speaking legally, we're here to empower you with one piece of a bigger, broader puzzle that we can show up knowledgeable and affect change in our communities. No one's coming to save us. We're going to save ourselves. So thank you all for being here. God bless you. And